Hi, my name is Joe. I'm a licensing and regulatory attorney here at Chapman Law Group. I specialize in defending the licenses of Florida healthcare professionals like yourself. I'm here to talk to you today about employer-ordered on-the-job drug screening and what happens if you fail a drug test. Now, as you probably know, you are required to cooperate with employer-ordered drug screening on the job. You are subject to it, and sometimes it does catch you by surprise. If it does, it's important that you not panic and that you remain aware of both what your obligations are and what happens next in terms of consequences so that you can make the most informed decisions, because some of the first decisions that'll be before you are some of the most important to how it ultimately impacts your license and your right to earn a living. While there may be perfectly valid concerns you may have about the drug test you're being subjected to, whether that's perfectly lawful prescription medications in your system, whether it's a desire to keep your medical information to yourself, whether you have concerns about how your employer is implementing their policy or whether they're fairly investigating whatever they're concerned about. The fact is, if you fail to submit to a drug screen, then it'll be inferred against you. It will be almost as bad as if they had actually found something in your sample. This is what will happen if you either fail a drug screen or fail to take one. Either your employer or yourself will report you to one of two Florida regulatory agencies. That will be either the Department of Health or to your profession's Impaired Practitioner program. It's because your employer may leave that decision up to you, and in any case, the decision will be yours if they report you to both and you're reached out to by one or both of those agencies. It's important to understand the differences between those two branching pathways and which is right for you, and how to make that decision in an informed way, because it can be very easy at that early stage to be intimidated into making the wrong decision. Let's start with the Impaired Practitioner programs. It's very important that you understand what these are. Your employer may try to give you a rundown and understanding of what to expect. These are often incomplete because a lot of employers will never have been in your situation before, and they have only a surface level or on paper understanding of how these programs work, or they may simply want to wash their hands of the situation and give you somebody else to blame if things go poorly. To me, it's very important that you have all the information to make this a real and informed decision. So, impaired practitioner programs, likely as you'll be told, are an off-ramp to discipline. They're an alternative to the DOH disciplinary process. You may have this information presented to you in a way that suggests that disciplinary investigation is the worst thing that can possibly happen, or even as if your choices are between the impaired practitioner program and revocation of your license. I cannot stress enough that that is not the case, and you absolutely do have the opportunity to gather the information you need to make that decision in a real and informed way at the time it's presented to you. Let me tell you a little bit about what the impaired practitioner programs are. Like I said, they're an off-ramp. They were implemented to give healthcare professionals with severe drug or alcohol problems or mental health disorders, impaired practitioners who could present a danger to their patients, with an opportunity to rehabilitate themselves, although far from easily, rather than face revocation of their license. It is a nuclear option for very serious situations and public safety concerns. It's important that you understand that because they're often presented as a precaution or as an adjudicator. You might even think that if you know that you're not an impaired practitioner, that you're not a danger to your patients, that you're good at your job, that you have nothing to worry about. If you have nothing to hide, you have nothing to fear. Even other parties, sometimes even the impaired practitioner programs themselves, might tell you things that give you that misimpression. I can't stress enough that that is not the case. The impaired practitioner programs are designed to deal with dangerous impaired practitioners, and they do have a very strong institutional habit of treating everybody as though they are one. You may be absolutely sure in your own mind that one drink a week, or the fact that you tried marijuana years ago, that nobody could possibly think you're a danger to the public based on that. But you may walk in for your evaluation before you ever consider, how do you ensure against the possibility that your evaluator simply decides that you're lying and that you need monitoring anyway? The only way is to make those informed decisions before you are faced with that danger. Because as a general matter, if you present to an impaired practitioner program, in almost all cases, they will decide that some monitoring is warranted.
Quick break. If you're a healthcare provider or an entrepreneur involved in healthcare and have a legal problem, whether it's compliance, regulatory, DEA, criminal, or any number of legal problems, Chapman Law Group is here to help. Please visit us at chapmanlawgroup.com. Click the link below. Now back to the video.
Now, to some extent, that is by design. The impaired practitioner programs do have a very low bar in terms of supporting impairment. They need only assess that there is a risk. And most of the professional licensing boards do have a great deal of deference for them. And once you have enrolled in a program, once you've gone in for an evaluation, they tend very strongly towards enforcing the decisions that have already been made by that program. So what's the alternative? Before you ever get there, you'll be told, and this is accurate, that if you don't report for the impaired practitioner program, then you'll be reported to the Department of Health. Now, like I said before, that is not a death sentence. It is not a foregone conclusion of revocation. It's not even a foregone conclusion that there will be discipline. The benefit to dealing with the Department of Health instead of the impaired practitioner programs is that in front of the Department of Health, there is a due process by which you can defend the allegations against you. There is a standard of proof. The Department of Health is burdened with the obligation of proving the allegations against you. They have to meet the burden of proof set forth in the law. You are entitled, if you do the right things, or better yet, if we do them on your behalf, to an evidentiary hearing in order to contest those allegations. Now, in front of the impaired practitioner program, you're likely to think that it's the way to go until you're presented with your monitoring contract, until you're told, what that process is actually going to be like, and then want to fight it. But by that point, you've already given them all the ammunition they need to establish a much stronger case against you. They'll have access to any health information that you gave them throughout the intake process. And if they report you to the Department of Health for not cooperating with their monitoring, that will be the charge. If you're investigated for non-compliance with monitoring, it's very hard to defend because that's usually easy to prove on paperwork alone. If instead you start from square one and we're defending you against allegations of impairment, that's much easier to do if the impaired practitioner program has never been involved and you're not on the run from them. After the impaired practitioner program evaluates you and finds that you're in need of monitoring, you'll be presented with a monitoring contract, at which point you really will have very little choice but to sign it and agree to it. It will be restrictive, it will be expensive. In most cases, there will be an incentive on the program's part to make it so, a financial one. They also will give themselves the authority to move the goalposts on you at their own sole discretion. So while there is a purpose to the impaired practitioner programs, there are situations that can be made better rather than worse by them. It's an extreme remedy for an extreme situation, and it's important that it not be done lightly. So what's the alternative? If you're induced to refer yourself to an impaired practitioner program and choose not to do so, then, as you'll be told, the alternative is that you'll be reported to the Florida Department of Health. And that may seem to you frightening, like a death sentence, like tantamount to being revoked. I cannot stress enough that it is not. In Department of Health proceedings, you do have the opportunity to defend yourself, and I urge you to do so with the assistance of competent counsel. The allegations they're making are presumed untrue rather than true. They do have to meet a statutory burden of proof. There are opportunities throughout that process to get your own word in, to make a case in your defense, to refute the department's evidence, and to present exculpatory evidence of our own. I cannot urge you strongly enough to make the best of those opportunities with the assistance of competent counsel. When I say competent counsel, I do mean specialists in the area of healthcare licensure defense who are familiar with the Florida Department of Health. We at Chapman Law Group do specialize in the defense of healthcare professionals and would be only too happy to offer our services to you in defending you through this process. If I leave you with anything today, it should be that if you find yourself the subject of a Department of Health investigation, you need a healthcare defense attorney who specializes in this practice area and understands the unique risks and aspects of defending a licensing case in front of the Department of Health. Your license is your livelihood, and I would urge you to leave nothing to chance. Instead, enlist our assistance so that we can do everything possible to defend you.
Hey, thank you so much for listening. Please like and subscribe and hit that little bell down on the bottom to receive notifications of our upcoming videos.